Gentleman from Henry, Mr. Armstrong.
Point of personal privilege, Mr. Speaker.
Gentleman may proceed.
Mr. Speaker, like you, I like nothing better in the evening after a long day at the General Assembly than to curl up in front of the fire and read the Code of Virginia. Yeah, I'm sick, but that's only one reason. And last night, Mr. Speaker, I was reading Title 2.2. Now, I suspect if I went into your office and pulled out the code, I might see the binding on 8.01 a little skinned up, or maybe in my office 18.2. But, you know, I rarely pull out and look at Title 2.2, but there's a section called 2.2500. Let me read it to you. It's real short. The Attorney General shall be the chief executive officer of the Department of Law and shall perform such duties as may be provided by law. And just a few statutes behind that, we learn that there is created in the Department of Law a division of consumer counsel. How about that? The duties of the division of consumer counsel will be to appear before governmental commissions, agencies, and departments, including the State Corporation Commission, to represent and be heard, get this, on behalf of consumers' interests and investigate such matters relating to such appearance. So, Mr. Speaker, if I read these two code sections appropriately, it seems to me the Attorney General is the lead consumer advocate when appearing before the State Corporation Commission, which does a lot of things, include regulate electric utility industries. Mr. Speaker, I've learned an awful lot about electric utility regulation the last year, maybe enough to last a lifetime. I would tell you, though, that there's something going on right now that has nothing to do with legislation in this state. Don't know if any of you saw an editorial by Christina Knuckles in the Virginian Pilot in the last few days. But in case you missed it, let me read you just a few lines. Dominion Virginia Power wants to tinker with the rate settlement case less than a year after the ink is dried. That leaves utility watchdogs and electricity customers with nothing but bad choices, if they have any choices at all. The monopoly utility is asking regulators at the State Corporation Commission to delay this year's rate increase until 2012. If the company's request is granted, its customers won't see a rate reduction until December 2014 at the earliest, even though last year's review concluded the utility was earning excess profits. Maybe you read in the newspaper that Dominion Virginia Power is, in return for pushing this case off a year, is going to give its customers $75 million. Well, you know, I'm guessing that they're doing that just out of the goodness of their heart, and it doesn't have anything to do with maybe being able to keep more than $75 million in excess profits by pushing this off. Mr. Speaker, I'm sure that you would expect the Attorney General to be jumping up and down. After all, he and I share something in common. Bashfulness is not a stronger quality of either one of us. But lo and behold, the Attorney General thinks that pushing it off is just fine. Northrop Grumman filed its objection a few days ago, and I am content, Mr. Speaker, that the major corporations and businesses of this state can look after their interests. They can afford lawyers. But what about the consumers of this state? Where's their lawyer? Where's their advocate? Where's their spokesperson? He can stand up and be involved in a multitude of lawsuits, but when it comes time to stand up for the consumers of this state, he's nowhere to be found. I suppose, Mr. Speaker, the Attorney General is looking after consumers in this state like Colonel Sanders is looking after his chickens. In the meantime, pay your electric bill. Thank you, Mr. Speaker.